Good evening, everyone. I am keenly aware that at once I have the fortune as well as the misfortune of being the final speaker before dinner. I will be quick. Earlier, Professor Haddad spoke of forced labor prosecutions in the context of Brazilian cases involving industries and companies. I will speak about domestic servitude prosecutions and pose in part this question: whether these types of human trafficking cases in particular pose a paradox for fact finders. Now, what do I mean by paradox for fact finders? Domestic servitude is a form of trafficking extremely difficult to detect and far more pernicious and insidious than other forms of labor trafficking, as some of you have already noted. For example, unlike trafficking victims forced to work on farms or in businesses where public detection of the trafficker's criminal conduct may more easily occur, the work of domestic servants is performed in private homes. Domestic work often occurs in the absence of any formal contract, and in some countries is not even recognized as work at all, nor a regulated sector of the labor force. Domestic servitude is also characterized by situations that increase these trafficking victims' vulnerabilities to abuse and exploitation, in particular due to their isolation, the fact that these victims are often not lawful citizens of the country where they are enslaved and so lack information about their rights, these victims' dependence on their employer for food and housing, and the fact that, at least in many of the cases in the United States, domestic servant trafficking victims are new to the United States with either poor or non-existent English language skills, therefore creating a critical barrier for these victims to notify law enforcement about their circumstance. And yet, in many domestic servitude prosecutions, fact finders and juries confront factual scenarios in which victims of domestic servitude recount instances in which they left the home of their traffickers to attend church services, for instance, or to visit family members. The victims often detail years of exploitation they suffered without seeking assistance from law enforcement or help from family and friends. Sometimes the victims engage in conduct that can be exploited by the traffickers to undermine their credibility. Evidence, for example, that the victims obtained a visa to enter the country where they labored by falsely claiming that they only intended to visit, not work. And just as frequently, these victims report accounts of their trafficking that involve neither physical force nor bondage. Facts, therefore, that on their face seem to contradict at least the general perception of what we think of as forced labor, an evidentiary paradox, if you will. But as the laws of many countries recognize, domestic servitude can and often does occur solely as the result of psychological coercion. In your passionate introduction, Monsignor Sanchez, in your powerful introduction to the summit, you remarked that, quote, "it is sadly common, but all too superficial, to reduce violence to pure physical aggression," unquote, given the new forms of slavery that, even in the absence of physical violence, still result in, quote, "wounded bodies and souls," end quote. Wounded souls. For those of us who serve as prosecutors, we bear the frequent difficult task of educating fact finders and juries to view the crime of domestic servitude through a more expansive prism of criminal conduct, one in which the trafficking can be and typically is achieved through non-violent means. Now, how as prosecutors do we persuade fact finders that domestic servant trafficking has occurred in the absence of physical force or other overt signs of compulsion? Fortunately, many countries, including the United States, define involuntary servitude very broadly, encompassing conditions under which traffickers compel a domestic servant's labor by, one, threatening harm to third persons, such as children or other family members; two, threatening the victims with arrest or deportation as the result of their illegal status in the country where they are working; or three, utilizing any scheme designed to cause a domestic servant to believe that her refusal to work will result in serious harm to herself or another. Rather than codifying actual violence as the sine qua non for proving this crime, United States lawmakers have enacted forced labor statutes that allow fact finders to convict traffickers of compelling the labor of these victims solely by the use of physical coercion and evidence of the victim's special vulnerabilities. Our courts have interpreted a victim's special vulnerabilities to include her background, legal status in the country in which she labored, experience, education, socioeconomic status, and power imbalance in relation to the trafficker's economic status in life. Our courts have made it very clear that a domestic servant who reasonably believes she cannot leave based on the trafficker's psychological coercion is under no affirmative duty to try to attempt to escape. In fact, a majority of the domestic servitude cases that my office has handled have not involved actual use of force or violence. Instead, we have relied on evidence of psychological coercion and the trafficker's use of a climate of fear to compel the victim's labor based on these special vulnerabilities. One case, for example, involved a male police officer, his wife, and the police officer's father-in-law, who just happened to be a judge. They had traveled, the husband and wife had traveled to India to recruit a woman to work as a domestic servant and nanny. They convinced her to believe that she would be treated just like a member of their family. She agreed to travel to the United States, and as you can surmise, upon her arrival, she was treated not like a family member, she was treated as a slave. As soon as her visa expired, they began to threaten her with deportation and arrest by law enforcement officers, telling her that if she tried to leave, law enforcement officers would come to their home and arrest her. But even more importantly, because the woman trafficker was from the same country as the victim and knew some of the victim's family members, she used the best psychological coercion of all. She told the victim that she would tell members of her family that she had entered into relationships with men who were not of her race or her religion, that she was involved in terrorism activities, and that she was a thief. This is a prime example, ladies and gentlemen, of where the psychological coercion was more than sufficient to compel the victim's labor. Those defendants pleaded guilty, and it is not uncommon in our cases, based on that type of similar physical coercion, to have very successful prosecutions in the absence of evidence of physical force or bondage. Now, what responsibilities do we bear as prosecutors, to assist fact finders by ensuring that we have taken steps to present the victim's story at trial to meet our evidentiary burden? Again, Monsignor Sanchez-Sorondo, in your introduction to the summit, you commended us to, quote, enhance appreciation of the needs of victims. And His Holy Father made a similar comment during his comments to us this afternoon, or maybe it was this evening, more specifically. For prosecutors, this idea of enhancing an appreciation for the needs of victims really rests on our duty to leave no stone unturned in searching for and ferreting out any evidence to corroborate the accounts of these victims, especially since these trafficking cases in particular involve so few witnesses capable of offering direct evidence of threats or force. In a recent case, that I handled, I traveled along with the case agents to the Kingdom of Swaziland, Africa, from the United States to meet with a victim in a domestic servitude case. She had made the decision that she did not want to avail herself of the benefits that could be offered through our immigration laws in order to stay in the United States after she was rescued. She wanted to get back to her family, who at the time of her trafficking thought she was dead because they had not heard from her in approximately 1 year. She wanted to go home, and she did. So we traveled to her. We met with her, we met with members of her family, we met with other witnesses who were aware of her account of trafficking, and just as importantly, were aware of certain statements that the traffickers had made to her in her native country in order to entice her to travel to the United States. That kind of international cooperation provided us the ability to obtain critical evidence to corroborate our victims so that our case did not rest solely on her shoulders. Frequently in our cases, we rely on multi-agency and international cooperation to provide avenues for this kind of evidence, and it becomes critical. We rely, for example, on the diffuse reach of the Department of State's Bureau of Diplomatic Security, whose special agents are located in every U.S. diplomatic mission and assigned to investigate these types of cases. But it's also important that we have these kinds of ties that we're forming here today and over the next day to form the kinds of attachments that we hope that we will with our international partners like yourselves. And finally, I want to make a point, or I should say underscore a point that has been made earlier, and that is the importance of public awareness campaigns and helping members of our communities, members of our churches, members of our civic organizations to understand both an awareness of how human trafficking looks, particularly domestic servitude cases, which again can be very hard to detect, but just as importantly, how important it is that we as prosecutors go outside our offices, go out to the public, and explain how members of the community can report these crimes. That is just as critical. So in conclusion, while this category of human trafficking crime can pose unique challenges to fact finders, involving inherent contradictions that can seem difficult for judges and juries to resolve, diligence by prosecutors, interagency collaboration by law enforcement agents, and greater public awareness and understanding of domestic servitude can all combine to serve the interests of justice for these victims, if not thwart the crimes altogether in some circumstances. And we all have our respective roles to play in this process, right? One case, one victim at a time. Grazie mille.